Good evening and welcome to the launch of Volume 46, Issue 1 of the University of New South Wales Law Journal. On behalf of the Journal, I would like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land on which we gather this evening. We pay our respects to their elders past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander people joining us tonight. My name is Matilda Grimm, and I am the Executive Editor of the University of New South Wales Law Journal. It is my privilege to welcome you all to the first launch of 2023, the launch of Volume 46, Issue 1 at Allens' Sydney office. Tonight's launch would not be possible without the generous support of Premier Sponsor Allens. Allens has supported the Journal for over 40 years and has played a key role in establishing the Journal as one of Australia's leading academic law reviews. I would like to thank in particular Lisa Miller and Eloise Tebbett for all the work they have put into organising tonight's event. I would also like to thank Tim Stewart, partner at Allens, for speaking on behalf of the firm later tonight. My thanks as well to the Journal's other premier sponsors, King & Wood Mallisons, Herbert Smith Freehills and Cause Chambers Westgarth, for their invaluable support. Issue 46.1 of the UNSW Law Journal is a general issue containing 10 articles that explore a broad range of legal topics. I would like to extend my thanks to all the authors featured in Issue 46.1, some of whom are here tonight, and for entrusting the Journal with their scholarly works and contributing to discourse on critical legal issues. I would like to welcome and thank Ms. Rachel Davis, Vice President and co-founder of Shift, a non-profit organisation regarded as the leading centre of expertise on the United Nations Guiding Principles on Business and Human Rights. She joins us virtually tonight to deliver a keynote address on the topic Human Rights, Corporations and Communities. All this would not be possible without the countless hours of effort put in by our student editorial board. I would particularly like to take the time to congratulate Enrico Manus, the editor of Issue 46.1, for all his work producing this issue. Enrico has been tirelessly dedicated to the production of this issue, literally working around the clock to see it brought to life. The editorial board is extremely proud of all that Enrico has achieved during his time on the executive committee. I hope everyone can see Enrico's passion and enthusiasm for the Journal manifest on the pages of this issue. We are incredibly sad that Enrico's tenure on the Journal's executive committee has come to an end, but are pleased to welcome Enrico's successor, Jessie Liu, who has already proved she is up to the challenge. My thanks as well to the rest of the Executive Committee. We have gotten off to a roaring start to the year, and I am so excited about everything we have on the cards for the rest of 2023. My special thanks to our digital editor, Zong Wan, for the hidden work that has gone into getting us all here tonight. But of course, the production of the Journal is not possible without the dedication of the editorial board. I would like to thank each and every one of our student editors for the hours of work they have put into editing this issue. Without our editorial board, this Journal could not produce a single issue. And last but not least, I would like to thank the UNSW Faculty of Law and Justice, particularly the faculty's Dean, Andrew Lynch, and our two brilliant faculty advisors, Rosalind Dixon and Gary Edmond, for their continuing guidance. In particular, thank you to Rosalind Dixon for delivering the vote of thanks later this evening. It is now my pleasure to invite Tim Stewart, partner in the banking and finance team at Allens, to speak on behalf of the firm.
Good evening, everyone. It's great to see you all here. Thank you very much, Matilda. I also would like to acknowledge that we're meeting here today on the lands of the Gadigal people, and another incredible day in the lands of the Eora Nation that they call home. I would also like to take the opportunity to pay my respects to the elders, past, present and emerging, and any of those in the room this evening. On behalf of Allens, I take great pleasure in welcoming you here this evening. It's the culmination of a significant amount of effort on behalf of all of the contributors and all of the editorial staff. It's great to be here for the launch of issue 46, number 1. I was here also for the issue of 45, number 1, 44, number 1. And as a former student of the UNSW Law School, I'm really proud to be able to be here and on behalf of the firm welcome you. As Matilda mentioned, Allens has supported the law review for over 40 years, since 1981. And again, we're extremely proud to do so. I would also like to take the opportunity to specifically welcome the UNSW Law Journal editorial board. Particular welcome to Enrico as the editor of issue 46.1. Rachel Davis, who will be joining us on the screen later. I extend my welcome to you as well. Unfortunately, you couldn't be here in person. But would also like to welcome Professor Rosalind Dixon as well. Thank you very much for joining us. I did note with interest that the topic for this issue is human rights, corporations and communities, and it's quite notable to me, who, as I said, have been hosting these launches for a number of years, how the journal just manages to choose topics of current significance, and it is again that this topic of the journal fits neatly into the national discourse. Considerations around constitutional recognition of the Indigenous voice, and the community and corporate participation in the mammoth task that we're faced with around climate change are two of, if not the most important and resounding discussions current topics of Australian national discourse. Now, I won't steal Enrico's thunder, but at a glance, these seem to resonate quite neatly through this issue's topic. With that, I would like to please invite Enrico Mainis, editor of issue 46.1, to speak next, and thank you very much for joining us.
Thank you so much, Tim, for that lovely welcome. The relationship between Allens and the journal and UNSW more broadly is a very special one, and it's one that we all cherish deeply. I would also like to thank Lisa and Eloise for all the work you've put into hosting us tonight. It's been brilliant. I acknowledge as well that tonight we are meeting on the unceded lands of the Gadigal people of the Eora Nation, and I also pay my respect to their elders past, present and emerging, and extend that respect to any Aboriginal or Torres Strait Islander people here tonight. Of the 10 articles in issue 46.1, 5 of them focus on the protection of human rights in some form. So I guess in a sense I feel a little bit lucky that the launch theme sort of fell into my lap and wrote itself. But in another, maybe luck didn't have so much of a role to play, because we are a generalist law journal, but with social justice so close to our identity and so many human rights issues becoming more pertinent as time goes on, it wouldn't surprise me if human rights would make a plausible theme for any general issue going forward. I think this is even more true now that we've established 10 article issues to be the norm rather than the shorter side of things. It just means that our publication criteria needs to be considered ever more thoughtfully and really guided by our vision for how we want this journal to shape legal scholarship in this country. So there are articles in this issue on the discrimination and violence wrought against First Nations peoples, which is a conversation we can expect to go on so long as this systemic injustice remains with us. There are also articles on combating the climate crisis, which we can expect to keep publishing on so long as there's still time. This is not to say that every article in the journal is going to address human rights emergencies like this one, but I do think that if we're interested in timely, impactful research, it's inevitable that much of our contribution will be able to be brought back in some way to the well-being of those being left deprived by our systems. Something that I do think is unique to this issue is its strong emphasis on community. So if we take the first article by Alan Zeng, who's here tonight, and everyone should congratulate him, that article considers how the Racial Discrimination Act can provide redress for state-inflicted violence, and the analysis on its own is so very rich, but the article focusing on the community of Palm Island in Queensland gives an impression of the true purpose of those reforms. And it's not just knowing about Mulrunji's death in custody and the police response that was found to have been in breach of the Racial Discrimination Act, but also the historical relationship between the police and the residents of that community and the everyday struggles and anxieties in that community that can be traced back to its colonial history and the violence that came with it. Similarly, in Beth Goldblatt's article on strategic litigation based on racially discriminatory climate harms. That's an article that probably also could have been written on a pure analysis of environmental law, of anti-discrimination legislation and UN conventions, but putting it through the perspective of the community of Moree just gives it another layer of meaning, and just getting to know that community's proud history of protest and activism. And in the article we hear from members of that community discussing how much work was put into trying to eradicate explicitly racial barriers to public goods, in this case, public cooling facilities. But having done all that work, they just seem to have been replaced with economic barriers, class barriers, which don't quite rear their heads in the same way, but are just as oppressive. So then when we go on to read the article by Jan McDonald and her colleagues on legal reforms to implement long-term carbon storage technologies, those are the kind of stakes that we have in mind. So I think a huge strength of a lot of the articles is a perspective on research that isn't in a vacuum, but is first and foremost an effort to empower people, family members, friends, neighbours, to have real material influence over the systems that are affecting them. It's also a reminder that when we are dealing with seemingly abstract questions of statutory interpretation or applying precedents or even changing the constitution, this is a human perspective of all that we really can't afford to lose in order to make the right decisions. I think the same rings true of the different kinds of communities that are explored throughout the issue. So Brooke Thompson's article discusses clashing community values in the context of enforcing Islamic wills. Brendan Walker-Munro looks into intelligence law and critiques the dangers of blending powers of surveillance and intelligence gathering with powers of enforcement, such as detaining and interfering with property. And Samuel Tyra's article, the final article, looks at access to justice for victims of family violence. And something that's alluded to in these last few articles is this concept of home as a base from which we should all be able to be safe and work and live. And that's complemented well also by Brendan Grigg and Hossein Esmaili's article that goes into planning law, in particular the right to a view, and has so much commentary on our connections to aesthetics and our surroundings and how the law deals or doesn't deal with our sense of ownership over those things. As to the corporations arm of the theme, there are 3 articles that between them talk about corporate governance and distributive justice. So Vivian Brand, Justine Lacey and Jordan Tudden share their insights from interviews with company directors on corporate social license to operate. Steve Carabas talks about crowdfunding as a way of taking power over corporate wealth away from shareholders in the traditional model and putting it with stakeholders and the general public. And then Matthew Harding queries whether private philanthropy is an ideal way of generating wealth and getting it to worthy causes and resources to where they're needed the most. So while a lot of the other articles go into specific communities and their needs, something that this set of articles does is raise the notion of the community as a whole, and the idea that there are principles and values of the community at large that can be harnessed to build better models of governance and resource distribution. And I think that there's an interesting dialogue set up with this and some of the other articles, where we have, on the one hand, the presence of many different identities and histories and imbalances of power that all need to be addressed. And on the other, maybe the tools for doing this could be underpinned by shared values and a mutual understanding of what just outcomes could look like. So I think that there's a lot of interesting conversations raised in the issue, and I do want to say a huge, huge thank you to the 16 authors for trusting us with your work and being so wonderful to work with throughout the entire publication process. We owe a huge thanks also to the UNSW Faculty of Law and Justice, particularly our Dean, Professor Andrew Lynch, who sadly can't be here tonight, but always speaks of the journal with such a huge amount of pride. It's something we appreciate really, really deeply. Special thanks as well to our faculty advisors, Professors Rosalind Dixon and Gary Edmond. Your expertise is so valuable, and you always give it so generously. We're very, very lucky. We wouldn't be able to do this without the support of our premier sponsors, Allens, Cause Chambers Westgarth, Herbert Smith Freehills, and King & Wood Mallisons. And again, a huge thank you to Allens for hosting this launch tonight. The vast majority of the substantive editing that's happened in this issue has been done by our general editorial board, our boardies. So I know that so many of you edited over Christmas, you edited over your summer holidays, or during your exams, or just after your exams when you should have been relaxing. And that's just for my issue. I know some of you are editing right now for future issues, and we have exams right around the corner. So you deserve a lot more than me just standing here and saying thanks. Ideally, like, you'd get to get up and talk about what you did in your editing, because it deserves it. But truly, the journal belongs to you and is great because of how well you look after it and your passion for it. So thank you. I've had the huge honour of running the day-to-day of the journal with the executive committee over the past 12 months. As we all know, the journal is an enormously prestigious institution, and the research that it publishes is of huge significance. But something even bigger than that is the workload. And honestly, it's something, this role I would have found insurmountable had it not been for the people I've gotten to work with and gotten to know. You are truly more wonderful than the work was hard, and I can't thank you enough. So executive editors Darius and Matilda, thank you so much for all of your leadership and your incredible kindness. Matilda, like, you've been in this role for just a few months, but it's really as if you've been doing it since childhood. You're like brilliant at it. To our digital editors, Cal and Zong, our forum editors, Jack and Izzy, and our submissions editors, Brad and Sarah, the whole thing falls apart unless each one of you is at the top of your game, which is not an easy thing. So thank you so much. I do want to say a huge thanks to our Volume 45 issue editors from last year, Kari, Akriti, Kat, and Georgia. You really were such a game-changing team, and I know that those of us on the current executive who also served with you continue to draw on your example. And to our issue editors for Volume 46 and beyond, Hayden, Ella, Anna, and Jessie, it's truly been such a privilege and such a pleasure, and you're all going to achieve really exciting things in the year to come. I'm very lucky as well to have such supportive friends and family beyond the journal. Thanks so much to those of you who are here tonight. It means a huge deal. Thank you to my partner Olivia. You're inspirational and super duper cool. And thanks a lot to Camilla, Chris, and Rob for your love and your support. And thank you to my parents, Sergio and Shaolin, for everything you've given. I also think community works well as a theme because it's so resonant with how the journal operates. And doing this has just reaffirmed for me that no matter how worthy the cause is, when you're in the thick of it all you really have are the people next to you while you do it. So obviously publishing an issue of the journal is important. It's why we're all here. I also think it's important because we're all here. And when we do this, we're investing not just in the end product, but also in each other, our relationships, and the belief that what we're here to do is support one another. And that's a lot easier to remember when you can just look around the room. So I'm just really grateful that we all get to be here together to celebrate this thing. Having said that, there is somebody joining us a lot more important than everybody else, and that's and that's our keynote speaker. We are so lucky to be joined by Rachel Davis tonight. Rachel is the co-founder and director of Shift, which is the leading centre of expertise on the United Nations Guiding Principles on Business and Human Rights. Rachel has spearheaded work on financial institutions, sporting institutions, human rights in conflict, and codifying all of these things into law. She's a graduate of UNSW and Harvard University, and most prestigiously is a former issue editor of the Law Journal. So it's inspirational and such an honour to have her speak tonight. So thank you again, and please join me in welcoming Rachel Davis.
Thank you very much, and I hope the sound is okay. I would like to begin by acknowledging that I'm speaking to you tonight, not from Sydney, but from the traditional lands of the Arakwal people of the Bundjalung Nation. And I pay my respects to their elders past, present and emerging, and I also acknowledge that sovereignty was never ceded. Thank you very much, Enrico, for that warm welcome, and to the whole editorial board for the invitation to speak, and to Alan's as host. It's a pleasure to do so, as you said, as both a UNSW Law alumni and as a former editor of the journal. I'm extremely sorry that I'm not there in the room with you all this evening. I was planning to travel to Sydney for it, but I caught a lovely bug on a recent work trip to Brussels, and it's probably better for all of you that I am not, and that I am just there remotely. I'd really like to congratulate Enrico. That's the first thing I want to do as the editor of General Issue 46.1, and the whole board as well. I know it's a collaborative effort. It was in my day, and it clearly continues to be. It's really impressive to see nearly 20 years on that the Law Journal is still run by a voluntary student board, retains its high reputation, and remains relatively unique in that regard. I do note the significant expansion in the number of members of the editorial board since the time that Professor Rose Dixon and I were students, and I'm sure that's a very welcome development for all involved, although it still sounds, Enrico, like it's an enormous workload from your comments just now, so that hasn't changed. The challenge I have, of course, in speaking about a general issue is that each article is focused, as Enrico has laid out, on a very particular topic and reflects deep expertise and research by the authors. So it's not possible for me to do justice to all of them in my comments. I'd therefore just like to acknowledge the very valuable contribution of all of the authors and the sheer diversity in their articles, but turn my attention to the theme of my comments tonight, which, as you've heard, is human rights, corporations and communities. And I'd like to do so by picking up on a comment that Enrico makes in his editorial introducing the journal, highlighting these interconnections. And I quote, "Terms like broader community and social values can be difficult to reconcile with the distinct histories and experiences of individuals and their own communities. Issue 46.1 cannot solve this, but it does affirm that meaningful change comes from listening to those harmed by injustice and ensuring their capacity to shape the systems that affect them." For the last 15 plus years, I've been privileged to work in the emerging field of business and human rights, although I think perhaps I can now safely say it's emerged, since my day job at the moment is focused on political negotiations to transform the foundational document in this field into a new corporate duty in EU law. I'll say more on that shortly. Business and human rights aims to bring the perspectives and the experiences of those directly impacted by business into companies' strategic decision-making to ensure that businesses act, wherever possible, with respect for the rights of those they affect. This includes a company's own workforce, it includes workers in its supply chain, it includes smallholders, miners, farmers, right at the upper reaches of the supply chain. It includes local communities around a company's sites or facilities, and of course, consumers and ultimate end users of a company's product or services. Business and human rights is still a relatively young field. In 2005, as a freshly minted LLM at Harvard, I began working as a legal advisor to the late Professor John Ruggie at Harvard Kennedy School. John had just been appointed by the then UN Secretary General, Kofi Annan, as the first ever special representative on business and human rights. His formal mandate was to identify and clarify standards and best practices in this emerging field. But his unwritten mandate was to help the UN Human Rights Council, a notoriously politicized body, for those of you familiar with it, to move beyond what had become a very solid stalemate between the states of the global north and the global south regarding the responsibilities of business for impacts on people. And his job was also to secure buy-in from business and civil society stakeholders alike while doing so. So this seemed like an interesting project for the summer after I graduated. But more than 15 years later, and after co-founding a nonprofit organization that specializes on the topic, I actually find it's more compelling than ever, given the scale of the human rights and the environmental challenges that are facing us today, as both Tim and Enrico mentioned. In my comments, I would like to do three things this evening. First of all, situate business and human rights for you in the wider movement towards stakeholder governance and the debates that is engendering. Second, explain how business and human rights provides a practical but also principled way of taking impacts on stakeholders into account in corporate decision-making. And third, to outline some of the significant legal developments that are occurring internationally in this field with implications for Australian companies and stakeholders alike. And I'll try not to cough as I go through. So my first point, business and human rights as part of the wider movement towards stakeholder governance. To set the stage, I'd like to just very briefly quote from an article that John Caroline Rees, my co-founder at Shift, and I published about the origins of this field, in which we said, quote, beginning in the 1980s, a series of ideological and policy shifts swept through the Anglo-American variant of capitalism. The shifts included weakening regulations, social safety nets, and unions. It included outsourcing government functions to private contractors, encouraging the ascendance of finance and the financialization of the real economy, and stipulating that maximizing shareholder value was the primary, if not the sole purpose of the listed corporation. Shareholder primacy, coupled with its correlative cost-cutting methods, have been major drivers of outsourcing and offshoring, of risk shifting and socializing externalities. It contributed to an explosion in executive compensation and stagnation in workers' wages, with short-termism a threat to both the long-term health of firms and of the societies in which they operate. And it was in the context of these business practices that the formal field of business and human rights was established. End quote. The 1990s and early 2000s saw the era of so-called corporate social responsibility, or CSR, which too often, I'm afraid, ended up as well-meaning social projects, but with companies cherry-picking issues to contribute to that were quite disconnected from their core operations and their business model, with no particular accountability attached. In 2005, as I've said, John was given an initial 2-year mandate to report to the UN Human Rights Council. 6 years, 50 international consultations, and a huge number of research reports later, the Council unanimously endorsed what he presented it with, the UN Guiding Principles on Business and Human Rights. This marked the first time that the UN had issued guidance to states and companies on their respective duties and responsibilities in relation to business and human rights. And it was the first time the Council had endorsed any normative text that had not been negotiated by governments themselves. That's a privilege they guard very carefully, so this was really significant. And it was that endorsement that put the guiding principles beyond a purely voluntary document and into the realm of soft law. The guiding principles are based on 3 pillars. Excuse me. First, the state duty to protect against human rights abuses, including by third parties such as business, which is grounded in states' existing legal obligations. Second, an independent corporate responsibility to respect human rights, that is, to prevent and address harms arising in a connection with a company's own operations or with its business relationships throughout its value chain. And third pillar, the need for victims to have access to effective remedy where harms occur, in which both states and companies have roles to play. The 3 pillars are elaborated in 31 principles with explanatory commentary. The former UN High Commissioner for Human Rights, Prince Zaid Ra'ad Al Hussein, who is now chair of Shift's board, described the guiding principles as, quote, the global authoritative standard, providing a blueprint for the steps all states and businesses should take to uphold human rights. The Economist described endorsement of the guiding principles as a watershed event for business. A decade later, we are now truly in the midst of a serious and much more mainstream debate than it has been previously about the purpose of the corporation and the role of stakeholders in that picture, with the question moving from whether corporate boards should take stakeholder interests into account to how to do so. And here I would like to touch on the timely contribution by Vivian Brand, Justine Lacey, and Jordan Tutton in the issue, which explores how growing attention to the concept of social license to operate also forms part of this movement. However, unlike that concept, which we looked at closely during John's mandate, the guiding principles are grounded in well-established definitions of internationally recognised human rights. Now, while this term may carry baggage for some audiences, it's not susceptible to the same criticisms of vagueness or lack of definition from corporate leaders. And it also brings a methodological rigour, which is derived from the nature of human rights protections themselves. And that's my second point. So what's different about business and human rights? Well, the guiding principles introduce the concept of human rights due diligence as the main management tool for companies to know and show that they respect human rights. This includes 4 steps, like any due diligence process: assessing actual and potential human rights impacts, integrating and acting upon the findings, tracking the effectiveness of a company's responses, and communicating how impacts are addressed. This construct was deliberately adapted from traditional legal, financial, technical due diligence processes that businesses are very familiar with, but that focus on risks to the business. Human rights due diligence, as its name suggests, focuses on risks to people. The key distinction here, methodological distinction, lies in the critical role of engagement with affected stakeholders. Human rights due diligence reflects the general categories of stakeholders, as I mentioned before: a company's own workers, workers in the supply chain, customers, communities, that are typically cited in reference to stakeholder governance. But it avoids the common critique that these categories are too expansive and the interests of their members too varied, it's too difficult for executives to make sense of. Instead, human rights due diligence places the focus on those people whose basic dignity and equality are most at risk from the ways in which business gets done. This is not about the loudest or the most influential stakeholders, but those who are the most vulnerable to harm, or potentially most vulnerable to harm. They may be company workers on low pay, 0-hour or unpredictable contracts, or who lack access to benefits, including LGBTQI+ individuals. They may be workers in global supply chains, women, migrant workers, those unable to unionize. They're often likely to include poorer, marginalized, Indigenous or minority communities who are displaced to make way for a new project or facility. Their livelihoods may be at risk from illegal land grabs or from the effects of climate change, or their very lives, in fact, may be at risk from the actions, for example, of public or private security forces. In almost all cases, they are the individuals and groups subjected to the greatest social and economic inequalities. These stakeholders' perspectives are vital to inform companies' understandings of human rights risks and whether the actions they are taking to reasonably try to prevent and mitigate those risks are actually effective. These stakeholders can help companies identify risks that may arise from the company's own activities. For example, from the pressure that apparel companies' purchasing practices put on their suppliers to cut corners on labour rights, or that tech companies' design and sales incentives put on their own teams to sell to clients who will misuse their products. Stakeholders can also help companies understand which risks are likely to be the most severe in human rights terms, even though they may not yet be financially material to the company. And of course, it's highly likely that the more severe the risk to stakeholders, the higher the material risk to the company becomes. But despite some quite significant progress since the guiding principles were endorsed and uptake of human rights due diligence, there's still a wide gap between corporate leaders and the vast majority of laggards in this domain. So a growing number of companies and business associations, alongside NGOs and trade unions, investors and others, have recognised that the only way to close this gap and ensure that treating affected stakeholders with respect becomes the norm the normal way of doing business, is for human rights due diligence to become mandatory. And that leads me to my third point, the rise of regulation grounded in the guiding principles. The guiding principles envisage that a dynamic or a smart mix of voluntary and mandatory approaches by states would be needed to transform how businesses behave on a global scale. The first 5 years of implementation were characterized by states encouraging voluntary action by businesses, often by adopting national action plans in this area. But these were often reactive catalogues of existing government policies, and they weren't really the kind of proactive approach that the state duty set out in the guiding principles envisages. Excuse me. From 2015 onwards, we started to see a growing use of mandatory human rights reporting requirements. Now, done well, human rights reporting can provide a meaningful window into the underlying performance of companies. But most of these first-generation reporting requirements were really lacking in meaningful consequences for non-compliance. Some of you may be familiar with the focus on modern slavery as a key topic of disclosure. Well, this really began with the California Transparency in Supply Chains Act, which came into force already in 2012, half a year after the adoption of the guiding principles. And that law was grounded in an assumption that if consumers were provided with greater information about how products were being made, they could play a greater role in the fight against abuses like modern slavery and human trafficking. But there's limited evidence of the impact of the law on companies that are subject to it. Now, a similar assumption informed the adoption by the UK government of its Modern Slavery Act in 2015. While it included a focus on board approval of corporate statements, the Act has rightly been criticised for lacking precision in terms of the actual due diligence that should underpin reporting, and for the absence of enforcement mechanisms, with the task of monitoring compliance essentially left to civil society and investors. Drafting of the Australian Modern Slavery Act in 2018 at Commonwealth level sought to learn from this experience, including by detailing what businesses are required to do and to report in line with the UN guiding principles. And the implementation guidance for the Act makes clear that companies are expected to be proactive and to meet the corporate responsibility to respect human rights. But again, it's lacking in meaningful consequences for non-compliance. Now, the New South Wales Modern Slavery Act went further in allowing for fines to be imposed on companies for failing to make or for making false or misleading statements. And it introduced the role of an independent statutory commissioner, which is a model now under consideration at federal level as part of the review of the Commonwealth Act. But modern slavery is only one salient risk that companies with significant operations and value chains face. And in some cases, they face other equally severe harms connected to their operations and should be carrying out their own human rights risk prioritization processes in order, with the input of affected stakeholders, as I said earlier, in order to determine where to prioritize limited resources. And indeed, the EU has recently amended its corporate sustainability reporting directive to require large companies operating in the single market to do just this, to carry out this kind of principled risk prioritization and action in line with the UN guiding principles. And those requirements apply to at least 600 large Australian companies who should already be starting now to carry out human rights due diligence to identify their salient risks in order to meet the first reporting deadline. The shortcomings of these various reporting laws really led to calls from many stakeholders for more comprehensive measures. And 2017 marked a turning point in this regard with the adoption of the French duty of vigilance law. This was the first legislation globally to apply comprehensive human rights and environmental due diligence obligations to certain large companies with consequences for a failure to meet them. Following that, plenty of other states started moving. We saw the Netherlands, Norway, and Germany, a significant economy, all move to adopt similar laws requiring due diligence, and there are proposals on the table in several other European countries as well. And this has understandably led to calls from business for the EU to level the playing field, which is precisely what is now happening. In 2020, the EU began negotiating a draft directive on corporate sustainability due diligence. Now, this represents a really significant opportunity to advance better outcomes for people and planet by scaling uptake of good quality human rights and environmental due diligence and enhancing corporate accountability for due diligence failures. European lawmaking, as many of you may know, involves three institutions: the Commission, the Council, and the Parliament. And I lead Shift's work to engage with all three institutions in seeking to ensure that the final directive, which we expect to see agreed in early 2024, is aligned to the greatest extent possible with the UN guiding principles. And again, once in force, this will have implications for Australian companies as well. Finally, just to round out the picture, it's worth noting that the US has taken a different approach by prohibiting the import of goods suspected of being produced with forced labour, rather than adopting a general due diligence duty. But the guiding principles remain the relevant standard here too, because the way to lift an import restriction order against a company's products is conditioned on demonstrating appropriate human rights due diligence. A similar approach has now been adopted in the free trade agreement with Canada and Mexico, so they are developing the same approach in those jurisdictions as well. And the EU is debating adopting a similar ban alongside its broader due diligence directive. So in conclusion then, a mere decade after the UN endorsed the UN guiding principles, which for an international lawyer like me is basically warp speed, they have turned the idea that companies have a responsibility for preventing and addressing adverse impacts of their business on people into an increasingly mainstream proposition with significant implications for corporate governance in time. Of course, large gaps remain between these standards and legal developments and outcomes for affected stakeholders in practice, and that's the urgent challenge that's dominating our time and our focus now. But as we work to tackle structural inequality and climate change, the two great challenges that face us as a society, human rights due diligence can provide a common and a robust methodology for ensuring that the perspective of those who may be most affected or most vulnerable to impacts are put at the heart of how business decisions gets made. And increasingly, companies will be required to do just this. Thank you very much for your time. And in closing, I commend the latest issue of the Law Journal to you, and we'll hand it back to the organisers. Thank you.
Thank you so much, Rachel. We're so grateful for you joining us remotely, especially when you're unwell. My name is Ros Dixon. I'm one of the faculty advisors. I want to begin by acknowledging, as Tim and Enrico have done, that we're meeting here tonight on Gadigal land and pay respect to elders past, present, emerging, and to Aboriginal and Torres Strait Islander colleagues here this evening. It's absolutely wonderful to have an alumna of both the Law School and the Law Journal speak to us this evening. Rachel, I think, is someone who uniquely brings a perspective on these ideas of community, human rights and the corporation. And Rachel, hearing the journey from 2005 to now and how, one starts with trying to develop standards and ends with a set of standards that are really clear and increasingly accepted. And we now have this unique moment of a mix of soft and hard law and the ways in which Europe continues to drive change. If those of you who underestimate Europe do so at your peril, every time you click a privacy button in Australia, it's because of the EU. And so the changes that Rachel's talking about are going to have a real impact on us. So it's really absolutely fascinating to hear that trajectory, to think about the relationship between environment and human rights and inequality, which a lot of the articles in the journal do really canvass. I'm a devoted swimming person, not as much as Justine Nolan, but still close. And, thinking about Beth Goldblatt's article about swimming pools in Moree, it takes us back to the freedom rides, but also that inequality, human rights and in climate nexus that Rachel talks about. So it's an absolutely wonderful keynote and set of reflections. I want to say something very briefly about Rachel, then the journal, and then thanks to Alan. So I think, Rachel's career is a real testament to what you're all embarking on. You're sitting here and thinking, what am I going to do? Maybe I'm going to be Tim and partner at Alan's, maybe I'm going to be Roz, but I think Rachel's career is the most important in showing you the possibilities that a UNSW Law Journal and law career open up for you. She and I were classmates at UNSW and at Harvard, and she's gone on to craft this amazing international career and help draft those, guidelines and then implement them from New York. COVID means you can now do anything from anywhere, so she's kind of in New York / Byron Bay. But her career really is a testament to the possibilities open to all of you. I think one of the things the Law Journal does, and that should resonate with those 6 years and 50 consultations, is it teaches you that rewards sometimes come slowly with a lot of hours and a lot of hard work. We live in an era of TikTok and immediate gratification, and if you can't get your sort of satisfaction now, it's hard to get the satisfaction at all. But I knew Rachel in that 2005 to 2011 period very well, and the amount of energy that team, the Ruggie team, put in to trying to develop guidelines that were likely to be voted down. That's what everyone thought at the time, and that really required, literally going all around the world trying to drum up support for a meaningful set of guidelines. That is like editing the Law Journal. Doing hours and hours of work of very high importance, but where you don't see the immediate payoff, and where it's really important that you're working in a team of dedicated, like-minded people. One of the things I liked most about your forward, Enrico, was that testament to community. I actually want to just read it out for those who haven't read it. Enrico says, the journal needs its community. Its work is too exacting and far too demanding to undertake alone. But then he says, part of the joy and the energy comes from working with people you care deeply for. More than it is a publication, the journal is an opportunity to support the good we see in each other. Its impact carries not just in its pages, but in the bonds between its people. And it's, I think, a very real testament to all of the work that you'll go in to do. If you ask the people at Allen's who like their work, a big part of what they'd say is it's the team that they work with. I feel that about my immediate colleagues and my global colleagues. And I think that the work you do in the journal is a huge part of learning the value of really hard individual work, but within the context of a supportive team. And I know that the Ruggie principles wouldn't have got off the ground without Rachel's work and that work of others in her, small team, but also that the rewards of building an international organisation such as SHIFT are a testament to the kind of work you can do with massive individual hard work, a lot of determination, and a sense that there's a longer term goal that you're contributing to, even when the immediate rewards are few. The journal is one of our crowning jewels at UNSW. We're incredibly proud of it and its long-standing tradition. As Tim said, Allen's has been supporting it for 40 years. It has had an even longer trajectory of success, and it remains one of Australia's preeminent law journals. I want to say, though, that is because of the hard work of those of you in the room. As someone who answers problems and, what happens when a problem arises, I know how seriously you take good process and the policies that you've written and how importantly you strive to uphold them and be fair and consistent and thorough. When you, have 10 busy academics reject you to referee, you go find an 11th, you don't cut corners, and you check again in a way that is really reflected in the work. The work is of the highest possible quality, not just in the final output, but in the process. And if you're in the journal as an author, you know that, but for all the authors who are not, they know that they've been treated fairly and with the highest standards. And that wouldn't be possible without the work of all of you in the room and the leadership of Matilda and Enrico and others in all of the editions, but particularly congratulations to you, Enrico, for this outstanding collection of articles. It is an amazing product and an amazing set of interesting and diverse reflections. My prior academic career was in the United States, and when you submit to US student law reviews, they often take a pretty quick read. I was talking to someone today who said that the average was about 2 minutes for a read of a US law review piece. But if you're famous, you probably get 5 minutes at least. And one of the things, if you go through, Enrico's done a beautiful job of summarising the themes of these articles, but if you go back and you reread them, I was just looking at it before I came up, there's people at the absolute earliest part of their career, Alan and others. There's the Dean of the Melbourne Law School. There are multidisciplinary teams from different universities. Without fear or fervour, the UNSW Law Journal looks at everyone's article and they spend dozens of hours, not 5 minutes, on every single one. And it's a huge cross-section of themes, but also of the talent in the Australian Academy at every stage of people's careers. And I think it's a huge testament to the work you did, calibrating and, collating that diversity of authorial experience as well as thematic experience. Finally, Tim, to Alan's, thank you so much for hosting us. I know our Dean, Andrew Lynch, particularly thanks Rachel and Alan's for the support. Andrew is at an event this evening which I briefly attended on my way here, which is about celebrating women at UNSW and the trailblazers who were first. And we're now putting new plaques all around the campus, which no doubt you'll enjoy seeing from tomorrow onwards if you're a student there. But Alan's has been really one of the most steadfast supporters of the faculty and of the journal. You and I were talking, Tim, before about the importance of the private sector and philanthropy in Australian education and in supporting our students and the endeavours that you do. And I think that we really couldn't have this kind of gathering or the journal and the excellence that it embodies without the support of firms such as Alan's. We're incredibly grateful, and grateful to be, as you said, Enrico, in the room together, getting to celebrate. I worked with a number of, Law Journal editors who didn't get to have any of this. They just sat in front of a Zoom screen and produced excellent work. A couple of them are kind of right at the tail end here tonight, so doubly celebration for them as well. But it is a great pleasure to get to toast you all and celebrate. I hope that you feel justifiably proud, Law Journal editors, of what you have achieved. And on behalf of the faculty, we could not be more proud to have Rachel, Tim, and so many of you amongst our students and alum and the community that we collectively are building and have built. And we really look forward to the next issue, but also to watching the careers of people here this evening who are effectively graduating from the journal. I know that Enrico's planning to do a lot of debating after this evening and moving on to other things, but people who've graduated and watching the careers that they will have, because they'll be in New York, they'll be somewhere in 20, 30 years doing other fascinating things, and you are not just a member of the small group that's here this evening. The alumni of the journal last forever, it seems. And thank you, Rachel, for reminding of us this evening. Enjoy.
Thank you, Roz, for that vote of thanks and for your lovely words. And thank you, Rachel, for your insightful keynote address. With Volume 46, Issue 1 of the UNSW Law Journal officially launched, we have now reached the conclusion of tonight's formal proceedings. Please feel free to remain and mingle for the next 20 minutes or so, and please do not forget to grab a complimentary copy of the issue. All of the articles in this issue can also be found on the UNSW Law Journal's website from tomorrow. Thank you all for your attendance, and I hope everyone enjoys the rest of their night.